Good morning, everyone. Welcome to the From Conference. I hope you're all trickling in. I want to welcome you to the session, What's So Funny About Peace, Love, and Ordinary Equality? The Modern Case for the Equal Rights Amendment. During the session, if you have questions, please feel free to type them in the chat box and we'll address them during the Q&A session at the end of the presentation. We will also have a discussion area after the presentation if you'd like to join us there. So be on the lookout for links to join that at the end. For now, it is an honor to introduce our presenter for this session, Cynthia Gentili.
Hi, thank you so much. And thank you for joining me today. As you said, I'm Cynthia Gentili. I'm a department chair and associate professor of human resource management at American Public University. I'm an attorney by training, and my academic focus is on intersections of business and law, especially employment and labor law. I've always found issues of constitutional law and legal equality to be fascinating, but also really important in my field. And so I've done a lot of research in the areas of constitutional equality. My presentation today is entitled, What's So Funny About Peace, Love, and Ordinary Equality? The Modern Case for the Equal Rights Amendment. And it's based on a paper published in the Law Journal, the 1865 in 2023. In this presentation, I endeavor to do a few things in a relatively short period of time. I'll provide some historical perspective on constitutional equality in the United States. I'll present a timeline around the introduction and the eventual ratification of the Equal Rights Amendment. And I'll ultimately argue why publishing the ERA is a critical step in the fight for gender equality in the workplace and beyond. Just one brief note before I get started. In this paper, the term woman or women is used extensively. I want to clarify that it is used to indicate here any female presenting person. More research is needed to develop the data around discrimination against non-binary, gender fluid, or other gender non-conforming individuals. Quick overview of our agenda for today. We're going to start with a discussion of constitutional equality and its history of excluding women. We'll talk about some early women who fought for constitutional equality, especially Abigail Adams and her husband, who didn't fight so much. I'm going to give a little background on the 19th Amendment and how the ERA fits into that. We're going to talk about the ERA over time, including how it started, ratification efforts and challenges, why the ERA is relevant today. And we'll talk a little bit about what type of protections exist either in the Constitution or using or applying federal laws, especially as it pertains to workplace protections for women. And then I'm going to give some information around gender equality and how it affects U.S. workers as compared to workers in the global economy. Then we're going to look a little bit at the gender pay gap and the time that it's taking to close. I'm going to talk about pay transparency laws and how they are a way to, or a stopgap measure to address some of this gender pay gap. And then I'll close with presenting an overview of where public support for the ERA stands now. So the foundation of the American experiment is grounded in the principle that all men are created equal. We all have heard this a million times. This directive is simple, but it's hardly simple in its legal, ethical, and eventual social application. While many men have been subject to something far less than equal rights under the law, no class or group has been as consistently excluded from constitutional equality as women. Our nation's forefathers knowingly created a division of rights and opportunities based principally on sex. In 1776, John Adams left his wife and family to join the Constitutional Convention convening in Philadelphia. His wife, the indomitable Abigail Adams, wrote John a letter with the simple instruction, "Remember the ladies." I have a quote from the letter here on the slide, but I'm going to read it. She wrote, "I desire you would remember the ladies and be more generous and favorable to them than your ancestors. Do not put such unlimited power into the hands of the husbands. Remember, all men would be tyrants if they could. If particular care and attention is not paid to the ladies, we are determined to foment a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation." More on that rebellion in a few moments. Abigail goes on to close the letter by saying that your sex is naturally tyrannical is a truth so thoroughly established as to admit of no dispute. But such of you wish to be happy, willingly give up the harsh title of master for the more tender and endearing one of friend. We know how this story proceeds, but John is said to have pondered this request, but ultimately decided against advocating for the inclusion of any language protecting women. He responded to Abigail's letter, stating, in part, depend upon it, we know better than to repeal our masculine systems. Although they are in full force, you know they are little more than theory. We dare not exert our power in its full latitude. We are obliged to go fair and softly, and in practice, you know, we are the subjects. We have only the name of masters, and rather than give up this, which would completely subject us to the despotism of the petticoat, I hope General Washington and all our brave heroes would fight. It takes another 144 years for women to earn a place in the Constitution with the publication of the 19th Amendment. Pictured here are some of the women from the National Women's Party, the group formed to organize public events to bring attention to the fight for women's suffrage. In 1917, the National Women's Party organized the first public picketing in front of the White House in the nation's history. Up until that moment, no one had dared to publicly protest the President of the United States. They would come to be known as the Silent Sentinels, a group of more than 2,000 women who non-violently protested in front of the White House during Woodrow Wilson's presidency. Alice Paul, the author of the Equal Rights Amendment, was an organizer of the Silent Sentinels. They dressed in purple and yellow. They held banners like those pictured here, pleading the case for why women's suffrage was more than just a women's issue. More than 500 Silent Sentinels were arrested. 168 of them served time in jail, including Alice Paul. Regardless of the risks to their life and freedom, women continued to silently protest at the White House for over 2.5 years, until June 4th, 1919, when the 19th Amendment passed the House and the Senate. While this presentation focuses on the Equal Rights Amendment, I'd be remiss not to provide some additional context here. Although women's suffrage was codified in 1920, in reality, these legal protections extended only to white women. The same voter suppression tactics used to keep Black men from voting, things like poll taxes and literacy tests, were extended to Black women. Indigenous women, who were not even considered citizens in 1920, did not have legal access to the ballot until 1924. But even as late as 1962, some states kept Indigenous women from voting by declaring residents of a reservation were not residents of a state. I want to spend just a couple minutes talking about Alice Paul, the author of the Equal Rights Amendment, as her life and work is the foundation for the modern case for the ERA. Alice was born in 1885 in Mount Laurel, New Jersey. Her mother was a suffragist and a Quaker, and Alice frequently attended suffragist meetings with her mother. Quakers advocated for the principles of gender equality, so this was a natural fit for her. Alice graduated first in her class in 1901 from a Quaker secondary school and then attended Swarthmore College, graduating in 1905 with a biology degree. She went on to earn a master's in sociology from Columbia in 1907 and eventually a PhD from the University of Pennsylvania in 1910. She moved to England, where she studied social work and joined the British suffrage movement, where she learned the protest strategies she later employed during the fight for women's suffrage, including those picket lines, hunger strikes, and other tactics and forms of civil disobedience. After the 19th Amendment passed, many suffragists left public life, but Alice did not. She believed the true battle for legally protected gender equality had yet to be won. With an eye towards championing another constitutional amendment, Paul went on to earn 3 different legal degrees to better understand how legislation and laws were drafted and passed. In 1923, Alice sought to capitalize on the momentum of the suffragists by fighting once again for constitutional equality, this time in the form of the Equal Rights Amendment. She famously said, "I never doubted that equal rights was the right direction. Most reforms, most problems are complicated, but to me, there's nothing complicated about ordinary equality." The text of the ERA is remarkably simple. It's pictured here on this banner. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. It does not focus on women exclusively. Instead, it seeks to guarantee equality for all, regardless of sex. Although Alice believed the time for the ERA had come, the ERA gained very little traction over the next 40 years. It was not until the emergence of the women's movement in the 1960s that ratification efforts gained momentum. In 1972, the ERA passed in both the House and the Senate and was sent to the states for ratification. Approval by 3/4 majority or 38 states is required to pass a constitutional amendment. Although the constitutional process for ratification of an amendment makes no mention of a time limit, Congress placed a 7-year deadline on the ratification of the ERA. I don't want to get too wonky here, but the 7-year deadline was added to the proposing clause, not to the body of the amendment. And this will be very important later down the road. In 1977, 35 states had ratified the ERA, but anti-ERA efforts began to take hold across the country. That same year, Alice died in a nursing home in New Jersey, having never seen the ERA pass into law. In 1979, Congress extended the deadline by 3 years to June 30th, 1982. But by that deadline, the amendment was still three states short of the 38 needed for ratification. Ratification efforts continued through the 1980s, 1990s, and early 2000s, but it was not until 2017, through the Herculean efforts of Nevada's State Senator Pat Spearman, that the ERA ratification fight was really revived. 35 years after the original deadline, Nevada became the 36th state to ratify the ERA. A year later, Illinois became the 37th state, and finally, Virginia in 2020 became the 38th state to ratify the ERA, ironically, 38 years after the deadline had passed. As I leave the history of the ERA behind, it's certainly worth noting that the 2023 bears little resemblance to 1776 or even 1976. It's reasonable to question whether we need a constitutional amendment to remember the ladies at all. I contend that the ERA is as relevant and necessary today, if not more so, than it was at its inception 100 years ago. As foretold by Abigail Adams, the ladies have been determined to foment a rebellion to gain constitutional equality for nearly 250 years. One of the things that the ERA would do is provide constitutional protections against sex-based discrimination. The Columbia Law School Center for Gender and Sexuality Law, founded by Professors Catherine Frank and Suzanne Goldberg, write and present on issues related to the ERA extensively. They contend that as a starting point, the ERA would usher in changes in sex equality protections by adding an explicit guarantee of sex equality in the Constitution, which would provide the strongest legal protection against future legislative attempts to roll back gender equality rights. It would modernize the idea of equality and equal citizenship that is protected in the Constitution. It would empower advocates and the courts to challenge discriminatory laws based on sex at the federal and state or local levels. It would provide a basis for courts to recognize pregnancy discrimination as a form of prohibited sex discrimination. It would require courts to apply the most exacting level of judicial review on discriminatory laws that are based on gender and sex stereotyping and bias. It would support an inclusive definition of sex that encompasses sexual orientation, gender identity and expression, and others. And it would bring the United States in line with more than 100 other countries with constitutional protections against sex-based discrimination. Right now, if a woman experiences sex-based discrimination in the workplace or places of public accommodation, current legal protections are based on the 14th Amendment. The 14th Amendment was passed in 1868, but was not applied in a sex-based discrimination case until 1971. And just 5 years later, in 1976, a case called Craig v. Boren held that men and women could be treated differently under the law if such treatment served a, quote, important governmental objection, without violating the Equal Protection Clause of the 14th Amendment. Briefly, in this case, an Oklahoma law prohibited the sale of non-intoxicating beer, that's beer that was 3.2% alcohol or less, to males under the age of 21, but to females under the age of 18. Ultimately, the court held that the statute made unconstitutional gender classifications. However, the really important part of this case goes beyond a legal drinking age. The lasting impact of this case is that the court found a gender-based classification is subject to what's called intermediate scrutiny, which means the classification must be substantially related to achieving an important government purpose. It's pretty relatively easy to prove. The court did not find that that classification was substantially related to achieving that stated government interest in Boren, but this would continue to be debated for the next 50 years. In fact, the late Supreme Court Justice Antonin Scalia unequivocally stated in his view, it was never the intent of the 14th Amendment to protect against sex-based discrimination. You see on the slide that here Antonin Scalia stated, "You do not need the Constitution to reflect the wishes of the current society. Certainly, the Constitution does not require discrimination on the basis of sex. The only issue is whether it prohibits it. It does not." Nobody ever thought that's what it meant. Nobody ever voted for that. If the current society wants to outlaw discrimination by sex, we have things called legislatures, and they enact things called laws. And that quote's from 2011. Opponents of the ERA often point to the web of existing federal laws that seek to fill the void of constitutional equality, particularly in the workplace. These include things like the Equal Pay Act of 1963, Title VII and IX of the 1964 Civil Rights Act, and the 1978 Pregnancy Discrimination Act. These laws provide significant legal protections for women, but since their passage, the legal applicability of each has been eroded. They create a complex history of courts applying or refusing to apply these laws in diverse circumstances. When a litigant brings a case under one of these laws, it's really hard to forecast the outcome. Cases are costly, they're time-consuming. The impact on judicial efficiency needlessly complicates a citizen's access to justice. Further, Congress can pass a law with a simple majority to overturn any of these acts. If the ERA was codified in the Constitution, it would be much harder for Congress to effect laws against discrimination based on sex. Further, if the ERA is ratified, a tougher judicial standard for review would be codified. In any case involving sex-based discrimination, the ratification of the ERA would require a court to apply the highest level of scrutiny, which is called strict scrutiny. You'll recall that at this time, we apply, or the court applies, a level of scrutiny called intermediate scrutiny. Under strict scrutiny, any law must be, quote, narrowly tailored to achieve a, quote, compelling government interest and be, quote, the least restrictive means of doing so. When viewed through this lens, unless there is a narrowly tailored, compelling state interest and no possible way to accomplish that interest in a less discriminatory manner, the court must strike down that law. This offers the clearest protection against sex-based discrimination. And clearer is better for everyone, especially businesses. I contend that the failure to specifically address gender equality leaves U.S. workers behind. It's clear that the failure here puts women in a poor position as compared to our global competitors. Of the 193 UN member states, 85% explicitly protect against discrimination based on sex in their constitutions. There is good cause for such protection. Research shows that high-impact, gender-diverse teams have a 21% higher likelihood of profitability. Further, when a new company has even just one woman on a founding team, there's a 63% likelihood that it will be successful. Yet women are statistically underrepresented in all levels of workplace leadership. 2022 was a record year for women in the workplace, with 53 Fortune 500 companies helmed by women for the first time in the list's 68-year history. While this statistic demonstrates positive momentum for women leaders, Another report from 2022 by McKinsey found that women leaders are switching jobs at the highest rate ever reported. The report synthesized data from 330 organizations employing more than 12 million people and surveyed more than 40,000 employees. Their research showed conclusively that companies struggle to retain the few women leaders they do have. McKinsey's report contended that 43% of women leaders felt burned out, as compared to 31% of men at the same level. There are myriad reasons for this, which include mental and physical impact of things like COVID-19 on women, the growing intolerance for workplace microaggressions, or the conscious rejection of the copious amounts of uncompensated labor for which women in the workplace are often tasked. Because of this, companies have a pipeline problem where fewer women are promoted to first-level managers, creating a dearth of eligible female candidates for higher-level leadership roles. This pipeline problem further complicates the impact of the, quote, Great Resignation, a term coined by Professor Anthony Klotz to describe the trend of mass voluntary exits of employees from their employment obligations. The Kinsey survey opined that for every woman at the director level who gets promoted to the next level, 2 women directors are choosing to leave that same company. Women who leave the workplace are not always leaving the workforce entirely. Research shows that women often leave to work for companies that prioritize diversity, equity, and inclusion. This is particularly interesting when viewed with the finding that women spend more time on DEI efforts than their male manager counterparts. Compared with men at their level, women leaders are up to twice as likely to spend substantial time on DEI work that falls outside of their formal job responsibilities, such as supporting employee resource groups, organizing events, recruiting employees from underrepresented groups. They are also more likely than men to take on allyship actions, such as mentoring younger women, women of color, advocating for new opportunities for those same women, and actively confronting discrimination. Of note, 40% of female respondents feel these efforts are not acknowledged by their employers in their performance reviews. So in this way, that DEI work becomes yet more uncompensated labor. Next, we talk about the gender pay gap, which is not closing nearly quickly enough. The gender pay gap has been slowly closing since the 1980s. But according to the US Census Bureau, women still make about 84 cents for every dollar earned by their male counterparts. At this current rate, it will take women until 2059 to achieve equal pay. Another surprising reality is that more education widens the wage gap between men and women. Women earn undergraduate and graduate degrees more frequently than the average American. Although in general, earning a college or graduate degree equates to higher lifetime earnings, this assessment fails for women across the board. Some researchers estimate that women with a bachelor's degree earn approximately 75% of what a man holding that same degree earns in their lifetime. Many people point to the Equal Pay Act of 1963 and ask why this disparity remains embedded in our economy. The goals of the Equal Pay Act were straightforward. It's equal pay for equal work. But in practice, this assessment is complicated. While the law requires that women and men doing substantially the same job will be paid the same salary, the determination is based on the job description, not the job title. To prove a violation under the Equal Pay Act, women must provide evidence that a specific employer intentionally discriminated against them, or that a specific employer's actions disproportionately affected her by showing statistically significant differences in pay between men and women. That statistically significant gap is extremely hard to prove. It's clear that the failure to specifically address gender equality leaves US workers behind. This graph shows where the United States is ranked against some of the 38 OECD, or Organization for Economic Cooperation and Development, nations, generally considered to be the world's most developed countries. Further, again, of the 193 UN member states, 85% explicitly protect against discrimination based on sex or gender in their constitutions. As I mentioned, research explored extensively, including in the 2022 book, The XX Edge, Unlocking Higher Returns and Lower Risks, shows that high impact gender diverse teams are much more likely to be profitable. And in many cases, new companies with women on a founding team are more likely to be successful. One of the biggest issues with pay, with closing the gender pay gap is around the issue of pay transparency laws. Many employers prohibit employees from sharing data on salaries. Government doesn't collect data on salaries, and employers are not required to disclose data on salaries. A recent survey of US employers suggests that 41% actively discourage their employees from simply sharing information about pay with their organizational peers, while 25% explicitly prohibit it. This map on the slide shows which states have advanced pay transparency legislation that requires the public disclosure of pay ranges under certain circumstances. Disclosing pay ranges holds employers accountable to market rates and puts women in better negotiating positions. Pay transparency is not a silver bullet to closing the gender pay gap, but researchers do opine that disclosing salary information could serve to expose more pervasive discriminatory factors when hiring and promoting. It's difficult for a woman to prove that she's receiving unequal pay when compared with a man who is doing the same job when pay data is not available. Even when a woman can prove unequal pay due to disparate impact or disparate treatment, an employer can prevail by showing a job-related or business necessity justification. So where does all this leave us? We know we have a tougher time proving discrimination based on sex. We have a pay gap, and we have spotty pay transparency laws. In the ensuing 100 years, public support for the ERA has grown, and it is a rare issue that defies political party alliance. Ultimately, we know that the ERA is as critical to women's equality today as it was to Alice Stokes Paul and her fellow advocates in 1923. 100 years later, progress has been made, and it must be acknowledged, but the ERA is the constitutional bridge to better outcomes for women, girls, and society writ large. This slide shows results from a 2020 poll, AP NORC poll, the most recent comprehensive polling around the ERA that is available. 74% of the population overall favors the ERA, including 89% of Democrats, 61% of Republicans, and 59% of independents. We dig into this polling data a bit more. About half of Americans say that the ratification of the ERA would be helpful for the country as a whole, and a majority think it would be helpful for women in particular. The impact for men in general is expected to be neither negative nor positive, and 40% of women say the amendment would have a positive impact on them personally. 43% of the women surveyed report experiencing at least some type of job-related discrimination, either around getting a job or receiving equal pay because of their gender. Interestingly, 19% of men report having been discriminated in either of these ways as well because of their gender. Ultimately, we know the ERA is as critical to women's equality today as it was to Alice Stokes Paul and her fellow advocates in 1923. 100 years later, progress has been made, and it must be acknowledged, but the ERA is the constitutional bridge to better outcomes for women, girls, and society. So I'll pause there to take any questions. I think there's some stuff in the chat.
Are there any questions, comments? I know members of this group have a lot to say on this topic.
Nyla, I see your comment about I'll be dead before the time the pay gap catches up. Well, I certainly hope that I will be, I certainly don't expect to still be working. How about that?
Yeah, I may not be dead, but yes, I will not be working anymore.
I see a question from, is it Jill? Yeah, about the negative impact of Phyllis Schlafly on tanking the ERA. Certainly, that is true. So between 1977 and 1982 in particular, anti-ERA efforts picked up speed, and that was really the reason why those last 3 states didn't come in. We had 35 states in 1977, and we still had 35 states in 1982. There was a lot of reasons why the ERA failed during that time period. some things that Phyllis Schlafly did that were either misinformation or disinformation, as terms we're very familiar with today. But ultimately, it did create enough of a question in society as to whether it was either A, needed, or B, beneficial to women. And that's how we stalled for over 50 years, or about 50 years. Any other questions? A dreadful woman. Her legacy continues.
Kelsey recommended a book titled Leadership Recreated, A Woman's Guide to Surviving and Thriving in Patriarchal Academia.
I'm not familiar with that, but that sounds like a great book. I would recommend a book that I used in this in my research for my article, which I did mention in the PowerPoint. It's called The XX Edge. If you're a policy wonk, if you're a finance person, if you're someone interested in data and statistics, the book is chock full of them. It's written by two women, one of whom was a medical doctor, and has gone on to do a lot of work funding women's initiatives and women's businesses. And then the other person is a finance person, who again shares the passion for supporting women in business. And the research that they did is astounding around the impact of the gender gap across the board. They talk about not just the financial impact on having more diverse teams, but also talk about the impact of women not being studied in medical research. Women, there's a whole chapter about using crash test dummies in safety trials for vehicles that aren't weighted the same as a woman's average weight. So it's just a fascinating book. I'd like to really recommend that one too. Anything else? Oh. So I see a question or a statement. I've heard explanations that when women have children, they themselves either leave the workplace temporarily or give less commitment to their jobs when they return, creating a gender disparity in pay and promotion. Is motherhood a factor or is it to blame? That's a question that deserves its own presentation, because there is truth to the statement that sometimes women who can self-select to change the trajectory of their career during motherhood or during the time of raising younger children. But that question can't be answered in a vacuum. We have to look at across the board women working at the lower end of the income economy to the higher end of the income economy. We have to look at the supports that are in place for women, whether they would make that choice if they did have the same supports. So when you look at the lifetime earnings of a woman, you might be able to pinpoint earnings losses attributable to motherhood or staying home to raise children, but that's not always the case. And a lot of studies will disaggregate that data so that they can pull out women who have children, women who do not have children, women who left the workforce, women who didn't, seasonal workers, full-time workers, part-time workers. So there is data around that. I feel like I missed a few here.
Natasha shared that there's a student poster presentation prepared by women at APUS about this topic and provided the link so that attendees can go view that presentation.
That's great.
Stacy Tucker mentioned another book, Invisible Women, Data Bias in a World Designed for Men.
Oh, that's very interesting. That's I would say that's in the same genre of the XX Edge, or at least it sounds like it. Yeah. If you're interested in learning more about the Equal Rights Amendment or about Alice Paul, I strongly encourage you to visit. I can actually put it in the chat, I think. The Alice Paul Institute. May have misspelled that in my haste. And they are actually I'm on the board for the Alice Paul Institute. I feel very passionate about the work that they do, and they have rebranded now to be the Alice Paul Center for Gender Justice. And the work that they're doing around the ERA, but not just the ERA, is really amazing. So can't recommend that enough for more information.
Another book recommendation, Power Mood by Sam DeMace. And Kinjo also provided the link if we want to move the discussion over to another space when we're finished here.
Thank you. Well,
I
I
know
hope this is informative. I'm sorry. I was just
no, you're good.
This is informative. I'm really happy that I had some questions that I was able to address in the chat. Thank you so much for making it interactive.
Thank you for the presentation. It was amazing to listen to and very informative. I was jotting down some things, and one of the first things I thought was all these women would have been founding members of the From Conference Committee. Like it was amazing.
Alice was from before From was from.
Yes.
Okay, then thank you. The next session will begin at 10:15. So we'll have a 25 minutes break now. Thank you.